Sir, let me say a few words about judgment on cheque dishonour case. And I have written a thematic judgment on cheque dishonour. And how does it thematic judgment? At first, I have discussed as to what is document, and the word document has been defined under section 3 of the Evidence Act 1872, and section 3 of Evidence Act provides that any matter expressed or described upon any substance by means of letters, figures or mark, or more than any one of those which is intended to be used or which may be used for purpose of recording that matter. I put a stress on the phrase for purpose of recording that matter. So whenever a transaction took place between the parties and it is reduced into writing by letters, figures, that is called a document. In the light of this definition, we can say that the cheque is a document. At the same time, section 29 of the Penal Code 1860 also defines what is document, and this section says any matter expressed or described upon anything for purpose of or more than one of these means, and which may be used as evidence. There is a difference of definition as to document between Evidence Act and the Penal Code. The Evidence Act says it is a recording, but section 29 says it would be used as evidence. And in the same way, section 29 of the Penal Code says in its illustration, cheque is a document. In the same way, section 2 subsection 16 of the Penal Code defines what is document, and in the same way, like the Evidence Act, it defines the document. From the analyzation of these three sections, we can say that initially a cheque is a document, and now we see how a document becomes an instrument. As per provision of as per definition of section 14, section 2 subsection 14 of the Stamp Act 1899, it defines what is an instrument. It says among the documents which purport to create, limit, extinguish, or extended any right to anybody, that document is called an instrument. Whenever a person drew a check directing a particular bank to give money written on the check to the pay, this document creates a title in favor of the pay, and the right of drawing money from the bank of the drawer has been extinguished. That is why this document, a check, is a negotiable instrument. And whenever a negotiable instrument may be initiated as per provision of section 13, of the NI Act, and it says how it is to be negotiated, how an instrument can be negotiated, that we may draw from the section 3 clause E of the Negotiable Instrument Act 1881, where it says issuance of checks. This section defines issuance of check and says the first delivery of a check, complete in form, to constitute the whole, to constitute the person holder, is called issuance of check. No, sir. Before doing this, we try to see what are the what is the form of a negotiable instruments. The section 6 of the NI Act 1881 defines cheque is a bill of exchange which is payable otherwise than by order. And the word bill of exchange is defined by section 5 of NI Act 1881, which says bill of exchange is a document in writing directing a particular person to give a sum of money in a future date, on a fixed date or a future date, to another a certain sum of money. If we analyze this to secure in section 5, we can see a bill of exchanges must have a 5 thing in it. That is the drawer, the person who draws it, and the person upon whom the drawer directs, that is the drawee, and the person to whom the payment is to be made, that is the payee, and a certain amount of money, that is, it is to be written in figure or words, and a certain date or a future date, that is the date. We have seen from definition of section 5, bill of exchange has five elements, and as per section 6, as the cheque is a cheque is a bill of exchange, so it must have the 5 elements. That is, a cheque, initially it is a document. This document records 5 things. That is, a particular name of the particular banker, a date, the name of the payee, and amount of payment, and the signature of the drawer. So, a document to be a cheque, initially it must have these 5 elements. And a cheque, whenever a document records all these 5 matters, it becomes a negotiable instrument as per section 13. 3 things are negotiable instruments: cheque, bill of exchange, and promissory note. And how it is to be negotiated? Section 14 defines it. And what are the conditions of negotiation? Before negotiation, a cheque is to be issued, and the word issued have been defined by section 3 clause E, where it is said the first delivery of cheque complete in form to make its holder to constitute a person its holder. What we have seen from the section 3 clause E, we have seen that this section says, yeah, the mode of drawing a check, and what is the mode? The 5 elements as it is laid down under section 6 and 5 and 6 of NI Act. It is to be described. It must be in the check. If any one of the elements are absent from a check, then we cannot say it as a issuance of check. If a check is not in issuance, then if a check not handed over by filling up all the elements as per law, this document cannot be an instrument and cannot be negotiated at the same time. So, to be a paper, initially it must be a document, thereafter negotiable instrument, and it is to be negotiated as it is said in the law. And now we can say that whenever a check is negotiated for 2 purposes, that is, for whenever a check is transferred by the drawer for purpose of payment as per provision of section 138, and hand over the check to another person for consideration. What I have said under section 9 of the NI Act. That is, whenever a person comes into possession of a check for consideration, that person is called the holder in due course. Holder in due course. Initially, the person at whose hand the check is found, he is to be a holder as per provision of section 8. And being holder is not enough. He is to be holder in due course, as it is said in the section 9 of the Evidence Act. Sorry, section 9 of the NI Act. Under only these 2 circumstances, that is, whenever a check is transferred for purpose of payment or transferred as a performance of a contract, then only then it can create a liability in favor of the holder. And if a person is not holder in due course or got the check for in payment of his credit, then the section 43 of the NI Act says that sort of check cannot create any obligation to payment to the holder. In this respect, I want to say another thing, what I always used in my judgment, that is inchoate stamped. Many of us mistakenly understand that if a check doesn't have any one of the 5 elements, may become a check, and they claim it with the reference section 20 of the NI Act, as because it is said whenever a person transfer a negotiable instrument incomplete in form, writing on a paper stamped paper with which it may be chargeable, the holder may complete it subsequently. But that is not the correct thing, as because section 20, though it is used to use the word negotiable instruments, but you know there are three kinds of negotiable instruments, and one is bill of exchange, promissory note, and cheque. Among these three negotiable instruments, only promissory note and bill of exchange is to be drawn on in stamp paper. But nowhere in the NI Act it is said that a cheque is to be drawn on stamp paper. And among the documents, which document is to be drawn on a stamp paper, we can see from the first schedule of the Stamp Act. This schedule contains the list of 64 documents, among which only Article 47 and 130 among the articles, only Article 13 and Article 47 contains that the bill of exchange and promissory note is to be written on a particular stamp paper. But nowhere in the Stamp Act, that is in the list of 64 documents under first schedule, it is not mentioned a cheque is to be drawn on a stamp paper. So, using section 20 of NI Act, somebody try to say that a cheque may be incomplete, cheque may be a blank cheque. But you know, throughout the NI Act, there is no such words used to mean blank cheque. There is only one word which is used in section 15, the blank endorsement. Blank endorsement. There is no such words like blank cheque. We may find a word blank endorsement. So, cheque never can be a blank. And you know, in our country, there is a lot of allegations, and I can say it, the most of the transaction done through the cheque, and the cheque is handed over having only the signature of the drawer, remaining three other elements not filled up, that is unfulfilled. If a cheque is handed over without filling out all four elements among the 5 elements, then it cannot be a cheque. Then it cannot be a cheque, and it cannot be a negotiable instrument. It cannot be negotiated, so it cannot create any liability. Section 58 of NI Act says, as per provision of section 58, we can say the holder of such a document have a defective title. I always use the presumption in favor of the complainant as per provision of section 118A of the NI Act in favor of the complainant, but it may be rebuttable. And how can it is rebuttable? The accused may rebut it. The accused may be rebutted. This rebuttable for the first time in the history of our legal arena. The appellate division, in the judgment of Abul Kahar Shaheen versus Imran Rashid, reported in 19 ALR page 25, in which the Honorable Appellate Division said that where there is a transaction and handing over a check, there must be a consideration, and without consideration there is no contract. And in support of transferring a check from one hand to another, there must have been a consideration. In absence of consideration, this transaction cannot be proved against the drawer. And facts mentioned in this judgment, landmark judgment, there was a contract between Shaheen Kahar versus Imran Rashid, and the contract was to sell out the land, to assist to sell out the land by the Abul Kahar Shaheen. And in this respect, there was a written contract and written and registered contract between them. And in pursuance of that contract, Imran Rashid Chaudhary transferred 4 crore, four checks containing the money written on it of 4 crore 50 lakhs taka as a commission of assistance to sell out the land. But finally, Abul Kahar Shaheen, after having the checks, did not assist in selling out the contracted land to others. And even as per the case record, Abul Kahar Shaheen did not attend the Tezga Dhanmundi, Tezga registration complex at the time of selling land by Imran Rashid, which he sold out of his own. And that is why, out of frustration, Imran Rashid asked his bank not to pay to Shaheen Kahar by writing a letter. And on that, the bank refused to pay whenever the check is presented by Shaheen Kahar. And being bounced the check, Shaheen Kahar filed a complaint against Imran Rashid Chaudhary under Section 138 of NI Act. And finally, Imran Rashid Chaudhary was charged with the offence of check dishonour, and the trial court, that is Sylhet Metropolitan Session Judge, convicted and sentenced with 1 year imprisonment and fine of taka 4 crore 50 lakhs, and in default of payment of fine to suffer another 1 month. However, Imran Rashid Chaudhary, being dissatisfied, being agreed with and dissatisfied, he preferred an appeal. And finally, the High Court Division set aside the judgment of the trial court. Being agreed with the judgment, Shaheen Kahar again prepares an leave to appeal to the Appellate Division. And taking hearing from both the sides, the Appellate Division, the Honorable Appellate Division, finally gives these landmark judgments. Every transaction where there is a handing over check, this transaction must have a consideration. Abul Shaheen Kahar did not assist in selling out the land. selling out the land, but yet that how can he claim consideration from the Imran Rashid? From that point of view, without assisting in selling out the land, Shaheen Kahar cannot claim commission from the sale money, and finally uphold, set aside the appeal. I always write the judgment on check dishonour case on the basis of those principles already I have submitted before you. That is why my judgment is totally different from others in the subordinate judiciary. Thank you.